everybody. Kimberly Lewis with ProSchool. I want to thank you for joining us on this Wednesday evening to discuss issues in uncertain times. You know, there's a lot of changes going on right now, especially, in California and in our local communities. And sometimes it's hard to know what's out there, what resources are out there, what things we can do to better ourselves, our families, and our communities with the knowledge. I have invited guests with me. The first one is attorney Joe Richardson from McCune Wright and Arvell here in Ontario. The second guest is Linda Jackson with Inland Empire Resource Center. Both of them have a wealth of knowledge, expertise, and information that we will be sharing tonight. I will also be talking about powers of attorney and how important it is to have those documents in effect before something happens. So kind of pre-planning in a sense. So let me go ahead, I'm going to read Joe Richardson's short bio, if I may. So Joe Richardson, who is an attorney, leads the Racial Economic Justice Program Practice Group here at the Law Office of McCune Wright and Arvell. It is designed to be a voice for the community. It is intentionally and uniquely positioned to bring actions against entities and institutions whose policies unequally harm people of color in the workplace and the consumer and small business marketplace. Obviously, that affects all of us. The group encompasses areas including employment, civil rights, and consumer and small business class actions. So I'd like him to discuss what exactly he does, kind of the issues with COVID right now, and the issues without COVID in the workplace, and what you can or cannot do. So I'm going to turn it over to Attorney Joe. Thank you.
All right. Thanks, guys, for coming. Info is power, and it's important to find out everything you can, hopefully prior to really needing it. So I want to talk a little bit about employment issues, and I typically will split them up in a few categories: gateway issues coming in and things going out. And things in the middle while you're in an employment situation. That being said, I'll still jump around a bit. Now, there is an admission that a lot of things are uncertain because of COVID. Okay, I think everybody knows that. And one of the things that attorneys thrive on, a couple of things, are certainty. And certainty is typically connected to precedent. In other words, when you ask us a question about something, our fallback is, okay, here's how we've done it before. Here's what the law is generally. But the thing that we don't get to say is this is what we did during our last pandemic, because our last pandemic was so long ago that one, none of us were here. Two, it was a very different world. So the next thing we'll do is talk about some of those issues to get as much certainty as we possibly can. Let's talk about the issues that people can expect. I'm going to come back to this for us in a second, but the way that we want to frame it, I think, is to say that as a general statement, wage and hour issues are still wage and hour issues in terms of requirements, in terms of things that are expected, in terms of things that employees have the right to, in terms of things that employers have the obligation to do. Those things have not changed. However, COVID-19, of course, has put a wrench in a lot of things, right? Because there's a question as to, okay, but now COVID is happening, and therefore what? Okay, and that's very fluid because we've got a moving target. As I'll talk about a little bit more in a moment here, Joe Biden moving toward requiring vaccinations in certain work environments is going to be a big thing. I already see reverberation of that in smaller companies. What ought we do? Should we be talking about vaccination status? Can we find that out? How? How do you do that without going too deep? And some of those types of things. So one of the things I'll address first is the idea that workplaces are short on employees. I don't know if you've noticed it, but you go to a restaurant, you go to place fill in the blank, and things are taking a little longer, okay? There's not as many people working, right? And so, therefore, employers have a stress related to how they get the work done that they need to get done. Has that changed the rules related to wage and hour? No, it is not. Right? So somebody will say, well, they're making me work a double shift. Well, they can, actually. As long as, one, you get your breaks that you're supposed to. That's thing one. And thing two, when you go in overtime, you go in overtime. Any number of hours, this is for a non-exempt employee, that is an hourly employee. Anytime over your 8 hours a day, over your 40 hours a week, is going to be overtime. Double time will be, time and a half after 8 hours, double time after 16 hours. Typically breaks every 2 hours, with every other break being at least a 30-minute meal break. That meal break can be at 5 hours or less, but there's supposed to be an agreement to that effect. Actually, let me rephrase that. There can be, there can be a lunch break by 5 hours, but there can also be an agreement that there is a 6-hour shift without a lunch break. There can be as well, but that has to be it in terms of the length. Now, that hasn't changed. That's not new. Okay. That's already there. Okay, so overtime, right? Time and a half, and then double time after 16 hours. Federal and state, anytime you're over 40 hours in the 168-hour, 7-day time frame, you are into overtime. In California, after you're over 8 hours in a day, you're into overtime. Okay. So that hasn't changed. That's still the same. Your rest breaks, your rest breaks should be uninterrupted, which is 10 minutes or less. Some people do 15 minutes. And your meal break, 30 minutes or more, should be uninterrupted. There are some exceptions, but as a general statement, it has to be uninterrupted. And if it's not uninterrupted, you're in the category where it doesn't have to be uninterrupted. It has to be compensated for. Okay? It's supposed to be uninterrupted. Now, if somebody decides not to take a lunch break, even though their lunch break is made available, their meal break is made available to them, the employer is not going to be liable. There were some cases related to that. So ideally, it's not a wink thing. You know, some employers have the brilliant idea to have people just punch out and keep working, but you're telling them and ordering them to do that. So there's no intent that you have your lunch break, that you have your meal break. Okay, you can't do that. But if I tell you, Jim, don't work for 30 minutes. I don't have to babysit you and force you not to work. I don't have to elbow you and tie you up and force you not to work. You know what I mean? I don't have to do that. I just have to make it available. Got it. Okay. That's always been the case. With what's going on now with COVID, what that means, though, is that there's a lot more pressure related to those issues. I normally see lawsuits on the employment side in 2 or 3 contexts. One has to do with wage and hour. Somebody doesn't get their wages the way that they're supposed to. They don't get them on time. I got one case right now where a guy got none of his checks on time, first one bounced. And then they fired him when he asked them about it. And they said, don't ask us about it, we'll fire you. He said, why? And they fired him. Okay, that's a case. Wow. So there's wage and hour, there's discrimination. In other words, you are in a protected classification. It could be race, it could be gender status, gender identification. It could be disability status. You are in a protected category. Something happens to you. The allegation is that it's happening to you because you're in that protected category. That's another box. The third box is public policy violation. I am at work and I complain because I didn't get my paycheck, I didn't get my meal break, I didn't get my rest break. I'm working overtime and not getting paid for overtime. Then there is an adverse employment action, which could be a termination, could be a demotion, could be any of a number of things. And therefore, there is a cause of action arising out of that. Okay, I typically see that, in those contexts. Those are the things that are happening. The rules in terms of what's required have not changed. Okay, so that's thing one. And hopefully that simplifies things for people dealing with COVID. I tell employers, let me say this. I'm going to say this to employees, and then I'm going to give a little something for employers because I've represented both. Employees, I say, this is a fluid time, and a lot of what we have going is some things that we don't have precedent for.
Right, constantly changing.
That's constantly changing. So while on the one hand, the employer does not have precedent on their side, employee, neither do you. If you have an employer that is fair, that does right by you, but perhaps has a technical violation, work with them and try to get them in line, but don't look for an opportunity to sue them out of business so you don't have a job. There's a whole lot of people that are getting done wrong by their employers. And if your employee is doing right, had an employer that's a good employer who got sued on the technicality because he knew when he was going on to a alternative work schedule that he had to do a private ballot for his employees and they all wanted it. He did not know he had to file it with the state.
Oh, got it.
So he gets hit for $80,000. Okay, that shouldn't happen. And there's a lady he fired twice, so no good deed goes unpunished. Right. So, so to employers, I say this: think about what would allow you to go above and beyond. I had a conversation with someone yesterday, and they said to me, "What can I do about a situation where I have a person that I know is very stressed, and part of it has to do with vaccination status?" I said, do everything that you can to figure out what they need to relieve the stress. Now, this is a person that works so hard, if you take the work away from her, she's still going to be stressed. Okay? So you have to find a way to do that, because I think that if you find a way to do that, you have a better chance to be okay if there's legal action related to it. So don't throw out the notion of common sense. I tell employers, don't throw that out. What seems to be the right thing to do in this circumstance? I had another situation where a person has a manager who manages the payroll, who apparently got sick but could not be contacted, was in the hospital, they couldn't contact them. He said, what do I do, and what do I do about her status? I said, does she have vacation time? Yes, for now, until you know what's what. Consistent with your rules, make sure you're paying her for the time. Right. Even though you could characterize and change the characterization somewhat later if you find out that it belongs in a different box. Right now, have it be paid vacation time for the next few days. Okay. Now, does he technically have to do that? Not necessarily, because among other things, he doesn't know the status. Right. It's not coming to work. There's an argument he could claim abandonment. That's not going to help him, particularly when she's the one with the payroll. He's trying to get the payroll done, so he's not in violation with the other employees. Right. Wow. So, don't get rid of the simplest notions of common sense. That's really important. So, safety standards related to, these are the gateway issues. When people come to work, before you hire them, can you require COVID testing? Absolutely. Can you inquire about vaccination status? Yes, if you have a legitimate business reason. You can figure out the what, but don't look into the why or the how. In other words, if you have a legitimate reason for understanding vaccination status, they're around a lot of people, they're around the public, etc., whatever the case may be, make sure that you find out about that vaccination status. But don't probe into why, because the why may be a disability issue, may be an ADA issue.
Oh, okay.
Okay? So leave the why alone to the extent that you can. Okay? Just like you would treat, here's where common sense comes in, someone else, pre-COVID, that comes to work and they're hacking and coughing all over the place. What's the concern with that? Right? Germs. Yeah. Right? Yeah, things like that. Same thing. And so you can, if someone has certain symptoms, put them off work until you understand what their status is. You absolutely can do that. You could do that before COVID.
But they're not being punished. It's just a safety precaution.
That's right. But they're not being punished. It is a safety precaution. Okay? You have to make sure that what you do in that regard does not coincide with someone not giving you the information that you want about vaccination, about this or about that, unless you have a legitimate business reason for something and it potentially puts other people in danger that you don't know it, but you keep it HIPAA private. Okay, so you're not having discussions about it, okay? There are certain requirements that we have, AB 685, which is new and is going to go to the end of January 2023. You have to notify employees of possible exposure and provide written notice that includes info on benefits available, anti-discrimination and retaliation protections, and employers' disinfection and safety plan. Most counties, you're going to have to notify a local agency of an outbreak, which is defined as 3 or more confirmed cases among employees in different households. You got to let them know, okay? The government, local agency can order a facility closed due to serious violations, okay? There is a workers' comp presumption when enough people to constitute an outbreak get sick in an employee's place. That was a big thing for a long time. At first, and I think I said this before in a previous event, the only things that were presumed to COVID, only areas where someone got COVID and that COVID was presumed to be a workers' comp injury. In other words, it's an employment-related injury, and so therefore the workers' comp statutes comes in, which is no fault, were at first agricultural workers and hospital workers. Right. Now there's more of that, and that can be in any place as long as the requirements are met for the what they call the outbreak. Okay, there is sick leave that folks can get. There's supplemental paid sick leave. Employees of covered employees, covered employers of 500 or more nationwide. Okay, and they can be subject to quarantine and those types of things. Employers can do a lot to keep the environment safe as long as they don't do it in a discriminatory manner. Okay? Now, there is a matter of what we must do and then what should we do. Going above and beyond, hopefully, or getting to a solution is often the order of the day. It may be easier to get to a solution if your employer has the resources and the work to allow you to work in a different alternative environment.
So like working from home.
Like working from home. However, and we'll see that this gets revisited, but to this point, working at home for accommodation purposes has never been a favored accommodation in the eyes of the law, because there's a presumption, in fact, that people are not as productive when they are working at home. Now, does that get revisited now? Probably, right, on some level. And here's the other thing. From employer to employer, you may seek an accommodation. Two employees, A and B, seek the same accommodations in different places. And because the employers have different resources, even if it's a reasonable accommodation, it might be an undue burden, hardship to do it one place but not the other.
Right.
So the fact that Jim got X or Y or Z at company X doesn't mean his brother Jay will get the same accommodation at the other place. Okay. So accommodation is about what the employer may have the ability to do, you working together to figure out, going through a good faith interactive process, to figure out what may be a good accommodation, but it's a separate question entirely whether or not there's an undue hardship in the employer being able to do it. So there's not a presumption that just because it's reasonable that your employer has to do it. If they don't have the resources to do it, you work at Del Taco, you can't work at Del Taco from home.
Right.
So there's no guarantee that way, right? COVID creates the impetus for more of these questions to be asked, but the questions and how they're dealt with have always been there. Hospital workers are required to be provided PPE. That's a little bit of a no-brainer, right? I've seen some people get sick early in the day. It shouldn't be happening so much now because of the lack of PPE or because of the moving target of what would be required from a PPE standpoint. Okay. Now about 6 months ago, we got the EEOC initial ruling that basically said employers would be able to require vaccinations. That goes back 6 months, but it was really just a recommendation. It did not have the force of law, was not sued. Of course, it's going to be litigated. Right. And we're probably in that process. That's probably cooking as we speak. President Biden has issued a requirement for all federal employees to be vaccinated, and as well as a great impetus for employers, even private employers, over 100 employees to do the same, which covers probably about 80 million people.
Oh, wow.
The question becomes whether and to what extent that becomes the impetus for smaller companies to do the same thing. Okay, it's going to be a litigated issue, but I will say this: that even though we are in an unprecedented time, but the thing that I should say first is that health government organizations requiring things of the public for health reasons is not new.
Right.
Okay, we've been here before in that way. So that may be a little bit of a window of where we may be going. We'll see. I guess we never know what may happen with the Supreme Court, not getting political, but we'll see what happens with that. But the handwriting seems to be on the wall that there will be a requirement or something close to it for people in certain categories to be vaccinated. So people may be going hard or easy, or whatever the situation may be. Some people be a little bit more recalcitrant about it. Right now, there's no right, by the way, of accommodation because I have a sick family member that I don't want to be exposed. And I work at a school, for instance. I got a family member in that category. No right to accommodate the fact that you don't want to work on site because you're concerned about your own exposure. Now, if the resources are there and it's not an undue hardship, it would seem to make sense and you're a good worker and all those types of things. Maybe your employer is inclined to work with you, maybe you're inclined to work with them. But those things aren't rights right now. But the rights that are still in place very much, and I'll close here and we can go from there, but the rights that are still very much in place are the things that are related to privacy. Employees feel a certain pressure, which I understand. So there can be inquiry about vaccination status. There should not be further information or pressure related to the why of the status. We will see if, how far down the requirements to vaccinate get, how far down they kind of trickle. But that continues to be fluid. But if what's going on at the top is an indication, we're probably going to get there before too long, even though a lot of this is going to be litigated. So those are the thoughts that I have right now. I'm sure there's a lot more out there. People can always ask us questions live if they want, or email us, get in contact with us otherwise. But those are the things that are on my mind right now.
No, I really appreciate that. We at Pro Se Legal, because we are a legal document preparation business, and we cater to the general public, get the most random questions.
Mm-hmm.
What can or can I not do? What is legal and what is not right? So thank you. You've actually educated me on some stuff. But yeah, I have a couple questions for you. I'm going to come back at the end when we do our Q&A. But thank you, Attorney George, and I really appreciate your insight and your expertise on this as well.
Okay.
My next guest is Linda Jackson. She is the Executive Director of Inland Empire Resource Center located here in the Inland Empire. Linda Jackson is a San Bernardino County resident for over 20 years. Linda's insight motivated her to build long-term relationships with the local churches to provide opportunities for families to move forward towards achieving their American dream. Obviously, it has to do with home ownership. In addition, Linda has formed partnerships with nonprofit and governmental entities throughout the Inland Empire. She is the recipient of numerous awards, including Woman of the Year from the National Association of Professional Women, that's awesome, along with several accommodations from the City of San Bernardino, Fontana, and the San Bernardino County Board of Supervisors. The State of California Senate, as well as the U.S. Congressional Certificate of Recognition for her outstanding work. Linda fosters a prayerful and caring work environment that allows many clients to thrive in their increased awareness and the empowerment received through resource counseling. And this is why I had brought Linda onto our webinar tonight, is to talk about resources. Again, we are in unprecedented times. Things are changing day to day. We turn on the news, a new regulation came. We turn on the news the following day, an old regulation went away. And so we're all kind of a little confused. What's out there when it comes to the housing issues? to the foreclosures, to, unemployment is coming to an end. So I've invited Linda to come and bring her expertise to talk about some of those housing issues, the forbearances, and the programs that are out there for people so that you don't go down that road. So thank you, Linda.
Well, thank you too, Kimberly. And doing the work out of the church, boy, you really have to be careful for what you ask for, because the work that I have to do in the church, it's bigger than I could have ever imagined, because it comes from your heart. And so what I want to talk about are the topics that you gave me, and forbearance is one that I know a lot of homeowners are in. A lot of homeowners are afraid of coming out and what is going to happen afterwards. And so the real thing that I find out that the problem is that we just don't have the knowledge. We just have no idea what to do. And so we try to figure it out on our own. And so the biggest thing that a consumer has right now is called a watchdog. And the watchdog that a consumer has right now is the Consumer Protection Financial Bureau. That's a lot there. It's called the CFPB.
Okay.
This is a bureau that works for the consumer. So whenever that consumer is not getting what they feel or believe that is fair, then they can actually file a complaint. So that is something that is very good for us. And because of the fact that there is a crisis, and this crisis is different. When I started in 2007, 2008, it was a mortgage crisis.
Right.
This is not a mortgage crisis. So it's a life and death crisis. So it's going to be handled totally different, and this is to the real estate community. It's not going to be handled the same way. And what I mean by that, people who are actually facing foreclosure, I know people are saying, what is going to happen to the people with foreclosure?
Right.
Actually, we cannot, or the banks cannot even start the foreclosure process before. They can't start it before January 1st, 2022.
Oh, wow.
So I really want to give people hope who are in foreclosure and figuring out, what am I going to do? I urge you to give me a call. And that way I can tell you what your options are. And really, if the bank can still work with you to get you out of foreclosure. So that's the first thing. Some people don't know what a forbearance is. A lot of us do. But here's the deal that people didn't know. I told everyone, if it was related to the CARES Act, the COVID Act, and people say, well, I don't have COVID. But if you had to stop working because the school closed down, because your kids had to come home, now you had to take care of them, that's related to the CARES Act.
Okay.
So just so that you know. So the thing is that if you have a government-backed loan, that's a Freddie Mac, a Fannie Mae, any government loan, and most of 90% of the loans are government loans, you could get help up to 12 months. That's a whole year of what a forbearance does. You still owe the money, everybody. I'm not telling you not to pay. But what that happens, the forbearance means that they freeze your payment. It just stops. And so what we found out, because it wasn't a mortgage crisis, it was a life and death crisis, it wasn't your fault that you couldn't make your payment. I had some clients who bought a home in March and the government shut us down because of COVID was so rampant, and just say in April, they made only maybe one payment or two payments. Typically, you couldn't get help from a bank unless you had 12 months seasoning, at least a year seasoning before you can get any help. You get help because it wasn't your fault. You lost your job. It wasn't your fault. You got sick. It wasn't your fault. So you're entitled, or you were entitled, to a forbearance. The other thing is that the waterfalls that we have now when you come out of the forbearance, because now the forbearances are ending, everybody thinks. They end at the end of September. The moratorium, it ends at the end of September, meaning the eviction moratorium, meaning that the foreclosure moratorium, it ends. But just like I said, because you're in foreclosure, yes, it did end, it will end at the end of this month. But they cannot start that process before January 1st, 2022.
So it gives you time.
It gives you time to get to me so I can help you
Okay.
figure out what we're going to do or what options are available to you.
Right.
So a couple of things that the government wanted us to get to you, help you understand that you do have hope. And it's called Waterfall Options. Now, you may not understand Waterfall Options,
Right.
but a HUD-approved counselor would definitely understand what that means. The problem that I'm finding out, and I'll tell you what a waterfall option is that, banks, servicers, their front line are not up to date to we are. They don't know the waterfall options. That's why I want you to call. So some of the waterfall options, partial claim. What's a partial claim? I want you to call me. Interest rate reduction. You know what an interest rate reduction is? A lot of the loans that I am looking right now, really the most recent loans I'm talking about, haven't made a payment or you haven't been in the house for 2 years, interest rate is high. And so the interest rate is a lot lower now. Right. So what they're doing is that when you waterfall, we want to reduce that interest rate so we can reduce that monthly payment. Or with a partial claim, we can reduce principal so we can reduce that monthly mortgage payment. Those are the things that we don't know because you just don't know.
Right. I've never even heard of that, but that sounds very, very consumer friendly.
Well, it is. It's not going to be as difficult. I bring back 2007, 2008. That mortgage crisis, that was subprime lending. This has nothing to do whatsoever. It is a life and death crisis. So, the other thing is, lenders will ask you, let's take a sip of water, a couple of questions. They're going to ask you a couple of questions. Those questions will be, can you afford to pay the money back? No, you can't afford to pay the back payments. What if you got a forbearance for a whole year?
Yeah, true.
So that answer is typically no. Can you resume your regular payments? Listen, everyone. Some of you might not be able to resume your regular payment. Don't say yes if you can't resume your regular payment because you're afraid of losing your home and then you go into it. Don't accept a loan modification if you know you cannot afford the payment, but you're too afraid not to sign on the dotted line because you want to keep your house. Right. I want you to call me before you do anything like that because some of the servicers are going to automatically send you out a loan modification. Don't sign it until you actually understand what you are signing. That is why we are here as HUD-approved counselors to understand. The first thing that we would have to do, guess what? Let's do a budget and find out where you actually stand. A lot of these loan mods are going to come to you with no documentation with some of the servicers. Some of the servicers are going to ask you for documentation, but I highly, highly, highly suggest that you don't do this without having a HUD-approved counselor. Now, back in the day, in 2008, it was told by the bank that 80% of the people who see us get the help. I'm just saying. You want to call. So let's talk about another couple of things that the lender is, or the servicer, I should say, is offering. They're going to send you in writing a repayment plan, a loan modification, want to make sure you can afford it, or a reinstatement. That's going to come in writing. I've seen some of the servicers send that out to some of my clients, and then I have to go back and say, these are the things that we need to go over to make sure. Let me say this and make it perfectly clear to everyone that's listening. Your hardship is going to be a great deal to how to put this together. What is the hardship? And the hardship must be must be COVID related.
Okay.
Okay, so that's the first thing. So you don't want to do any of this without my help. There are other things that are just coming out. As my drive over here, I'll go to that next. I'm going to tell you what just came out because things are changing every day. So you might think you got this information, but tomorrow there may be something else new. So don't hesitate to call me, and my time is running out. So this is it. It's called Mortgage Release Assistance. So we never had mortgage relief assistance. Never in 2007, 2008, it didn't exist. What that means is that you can get help, you can get money. There's money for you to pay your back payments. So with the city, I don't know if they still have money. I don't want to put Fontana out there, but Fontana had up to $20,000 to pay your mortgage payments. I don't know if they still have money, but they did have money. So we can always check if you call. Hardship, COVID related, I gave you some samples, examples of lost employment and children out of school. That will help you really say this is COVID related. So here's why, one of the other things that I'm finding out too that is hurting homeowners. A lot of you got unemployment, right? That just ended. A lot of you were paying your mortgage with your unemployment. That wasn't a good idea. The idea is to put you in a forbearance, to freeze that payment so that you can find a job. And that would have given you, if the pandemic didn't prolong itself, enough time for you to find employment. Because now you don't have that extra money that you thought you would have. So I need you to call me about that as well so I can help you. The other thing quickly we wanted to talk about was the eviction moratorium. The eviction moratorium for the rent, it is up at the end of this month. However, there are emergency funds for you, and it's actually called Emergency Rental Relief Funds. Today, LA just received $5.2 billion on that fund. And the federal government, and it's for, what it's for, I just read it today, it's for renters and it's for landlords. So landlords, it's important. I know you want to, file an eviction because you want to get paid and all of that, but the money is there for you as well, just like it is for the renters. And really what's going to happen is that when you go to court, they are going to want to know, did you apply for that money for yourself, landlord? Prior. So that's important before you just go do that, because we're dealing with a public health emergency. So, the last thing we want to do is to evict people. So that's not going to be a simple process, because right now what they're doing is, for the example, they have a new program, and that's called the Diversion Eviction Program. The Diversion Eviction Program is just what it says. They want to divert from the eviction process. And the way that they are going to do this is that, so they want to mitigate. So what they want in that process is that they want to make sure they have communication. The judges want to make sure, have you communicated with the landlord or property management company? That is going to be key. Did you talk to a HUD housing counselor? Do you have an application in the queue to get assistance for your rent? Have you talked to legal aid, or have you talked to an attorney? If you say no, the model is being used, I want to say, in Philadelphia and some of the East Coast. It's being used right now, called the Diversion Eviction Program, is that the judge will have maybe legal aid in the court when you go for the eviction, or have a housing counselor in the court. And before he would even evict you, he'll tell you, go talk to legal aid, go talk to the housing
Right.
counselor. So it is so important that you contact us so we can put you in the hands of where you want to be. We're funded by the state of California, so we handle LA, we handle all of the
Okay.
state of California. So this is huge, and rental assistance is available for up to 18 months of back rent.
Oh, wow.
So that's it. And also there's utility assistance that can help you. There are also relocation assistance included. Also, they'll help you with your deposit to even get into a place. So this is very, very crucial, new information, changing every day.
Right.
But all I can say is give me a call so that I can help you, navigate you through the process of even filling out the application. Let us help you. It's taking about 45 days to get the money out, but the judge is gonna say,
Right.
are you in the queue? So let's do this. Before the end of the month, call me so I can get you in the queue.
I like how you said that. Call me so I can get you in the queue. You know, a lot of times people wait until the very last minute to take care of stuff. They have a work issue, and they just keep working that extra overtime, you know, and a year or two has gone by and they don't realize. You know, then all of a sudden, you know, I haven't paid my rent or my mortgage in so long, and now the time is coming, and that's why I had brought you in, because so many people, we get so many phone calls at Pro Se Legal, you know, I'm going to be evicted. No, there's a lot of resources out there. Let me have you call this individual first. So what I also want to talk about are power of attorneys. You know, a lot of times people, like Linda said, wait till the very last minute to do something.
I know.
Power of attorneys are there to help you when you need it. When you're financially unable to make those financial or healthcare decisions on your own, the document allows you to appoint an agent to go ahead and to make those financial decisions for you. Write that check so you can pay your mortgage. You know, possibly be able to call your employer to say, hey, so-and-so is sick at home, they're unable to get their check, can I pick up the check so I can go ahead and deposit it into their bank account? And I look at power of attorneys as car insurance. Everybody has to have car insurance. You're not always going to get into a car wreck.
Right.
You never know. But if you do, then you already have a vehicle insurance there to go ahead and to help you. Power of attorney is the exact same. You know, I may not fall down and break my hip and need my agents or my children to go ahead and to assist me. But if I do, then at least I have that document to go ahead and to make that happen. And a lot of times, you know, when you have a wage issue or you have, you know, an issue at work, it's an employment issue, you're out of job or you got wrongfully terminated or whatnot, it then turns into a housing issue because now you're unable to go ahead and to pay that mortgage or to pay that rent or to do anything. And then now you need a power of attorney because it's affecting your health. You know, we have a lot of clients who call, and I'll share a couple stories with you. We had a lady who was a senior. She got very sick. It was not COVID related, got very sick. Went into a rehab center. Well, the apartment that she lived at, there was no power of attorney or next of kin or a contact for her. So the apartment complex didn't know what to do with her all of her belongings. Rent hadn't been paid for 4, 5, 6 months, so they ended up discarding all of her personal needs. So here she comes out of rehab and has nowhere to live. Nobody ever acted on her behalf, and now people are scrambling as to where is she going to go. Another situation, we have a nurse who had contacted our office. She was a nurse from Florida. She got called to California to help with the crisis here with COVID. Her mother was in charge of her children, but she couldn't enroll them in school because they didn't have power of attorney. That was new. It was like, oh my gosh, we need a minor's power of attorney for grandma to go ahead and to enroll these kids in school because mom's out of state working to go ahead and deal with whatever crisis. So it's just those kind of random things that you never think about. I have a daughter that went to college, and I know Joan and I talked about this earlier. She had gone to college, and I'm paying for her apartment, I'm paying for college, I'm buying her books and her parking pass, and what do you mean you won't give me the information? She's over 18,
right.
sorry.
It's wrong.
You know, she needs to go ahead and, and give you authorization, and I thought, no, I'm gonna go ahead and have her sign power of attorney because she's unable to manage X, Y, and Z. On a sadder note, we actually had a gentleman recently call us. His wife had a stroke, was in the hospital. the gentleman calls us and says that the hospital is asking for power of attorney. He's saying, why? I'm the husband. I need to make decisions for her. She unfortunately had lost capacity, and he didn't understand, I'm the spouse, why can't I go ahead and make those decisions for my wife? So I want to look at power of attorneys as, again, vehicle insurance. You may not always need it, but for a couple $100, it's well worth getting all of your ducks in a row, so to speak. So then that way, if you have a financial problem, somebody can come in and assist with that when you're unable to. If now you have a housing issue, you're stressed out, stress does amazing things to the body. I visited with a gentleman the other day at a senior living. He's 55, he had a stroke due to stress. There we were going to go ahead and decide on the power of attorneys. He just doesn't think about it. Nobody thinks about it, until you have to think about it. So I really want to encourage our audience and those that are going to look at this later, when an issue arises, when it's a housing issue and you've lost your job, you're wrongfully terminated, and you need a resource. We here at Pro Se Legal have a resource. Now that's going to affect your ability to pay your mortgage, your ability to pay your rent. Maybe you're at home taking care of a sick person because of COVID, and your employer just didn't know what was right and what was wrong. Now you don't have a job. But now there's a resource to help pay for that rent or for that mortgage. Half of what you spoke about, I have no clue. And I think I'm pretty informed, And I was like, oh my God, what I mean? Maybe I shouldn't have picked my mortgage or something. Those are actually wonderful programs. I want to go ahead and open up to our audience for any questions that they may have for Linda or for Joe or even myself. I have a situation, or I do have a question for you, Joe. So I know you had talked about, overtime and shifts. What I'm seeing is, especially in the fast food industry, because they have a lack of employees, is they're wanting people to work double shifts. Well, if you put shift 1 and shift 2 together, that's like a 10-hour day.
Right.
Or more. Or more, exactly. So if they're working a 5-hour shift, and then they're off for 30 minutes or an hour, and then they come back, and now they're working their double shift. You know what I mean? Mm-hmm. Somebody called off, or they're just short, and now they're working their 6 or 7 hour. In my mind, when you calculate that, that's over 8 hours. But so is part of that considered overtime, or how is that calculated?
It's going to be, because if you're over 8 hours in a day, you're in the overtime.
Even though there were 2 different shifts. So
there are 2 different shifts, but you're still there on the same day.
Got it.
I guess restaurants can get a little hairy about timing. Some restaurants close and late lunch and then reopen at the dinner hour,
Yes. But
they're still working in the same day.
Right.
So if you go over 8 hours in the day, you go into overtime. The fact that I had another one that's kind of slick. I just had this conversation today. This gentleman worked at several branches of a restaurant. And so from day to day, he didn't know which one he'd be working at. Mm-hmm. So he'd be working at the restaurant, and he would get enough hours where he's working 30 to 40 at each one, but let's say 20 to 30. Well, it's the same company. Oh. So they can't give him 2 or 3 30-hour checks with no overtime.
Got it.
So overtime is still overtime. What you have to presume is that if somebody is over 8 hours in the day, it's going to be overtime. Also, that they're supposed to have rest break, meal break at 5 hours, or between 4 to 5 hours. But there can be an agreement to get off work at 6 hours with no lunch break. Okay, there can be an agreement, and that's a whole thing of its own. But double shifts can happen, and it's happening more often, particularly in that area or whatever else. But you really go off hours, and of course, the assumption that we're making is that the person, of course, it's going to be that way in the restaurant industry, is non-exempt. In other words, they're an hourly employee. Right. And by the way, BTW, like the kids say, BTW, IJS, sometimes WTF, WTH. Okay, what the heck? The other thing that you have to remember is that person A and person B, person A employee and person B employer cannot make an agreement to take the employee's work or the related obligations out of the category that the law has set. So in other words, I can't say, okay, I'm going to waive my right to overtime and have that carry the day. If I wake up, I go talk to Joe Richardson, and I'm like, you're entitled to X number of hours of overtime.
Right.
The employer or, Jim Bob manager can't say, but you said you weren't, going to come after that. We agreed to that. Or, and this is a little bit of a different issue because a lot of times we're dealing in the context of hourly employees. But if your job ought to be hourly, which means that it's non-exempt, but you guys are making an agreement that they're exempt. You know what I mean? Your exemption is not about you being exempt is not about what you agree to. It's about what the law actually is. Just like being an independent contractor versus an employee is not about what you agree to.
Got it.
Okay, so you agree to it, and that's fine and good and well until the law catches up or someone changes their mind. For one reason or another, there can be an evaluation of the independent contractor relationship, and over the last year or two, by the way, the Uber case, there's an Uber decision with the courts that basically says that Proposition 22 is unconstitutional. So what that means is that, Uber spends a whole lot of cheese, a whole lot of money getting on the ballot and getting an exception to the general rule that when you have control over an employee, that means that they are a worker. That means that they're an employee. They made a decision that they would apply outside of that and have an exception. Well, the courts have said no. So that, is going to be fluid for a while, and we'll see where that goes. And I will say, actually, in candor, that California does have to do some things differently because so many people are in a economy.
Right.
And not everything fits in a category, but it's a perfect. You can't then decide if the law has said you're an employee under your circumstances, that you two are going to make an agreement that you're an independent contractor. It's about the net you do and whether or not it falls in an exempt category. So any agreement is, off the table as soon as the law recognizes it. It might come up because of a workers' comp issue. Right. It might come up because you file a wage claim, wage and hour labor board, which can be a good alternative to going to court. That's another reason you'd want a power of attorney, because the person with the power of attorney can bring that on your behalf if you can't do it. But sometimes the threshold question is whether or not this person is an employee. And depending what agency you're dealing with, depending on whether you're dealing with us, whether you're dealing with the Department of the DIR, dealing with the Labor Board, the requirements are different and very hairy. But as a general statement, the question tends to be about how much control the employer has over the employee. And speaking of which, let me jump here. We'll ask, do I have to pay for my custody if I'm a worker? Do I have to, is it paid time for you to be a worker, to get tested or to go get vaccinated? And the general rule is we as employers, when an employee is in our control, doing things at my direction, under my control, everything we do is compensable. And everything that they have to undertake related to their employment is reimbursable or has to be handled on one end or the other by the employer. So that means that you should not be paying if you're an employee for your COVID testing. You should not be paying if you're an employee for your vaccination. And at the time doing either is paid time because you are under control of the employer at that time. Similarly, if it's traveling, traveling had been happening a whole lot lately, but it may be up a little bit more. In California, if I am traveling for work outside of business hours, that is compensable time as well, even though it doesn't necessarily have to be at the same level that you normally get paid. But it is compensable if you are an hourly employee.
If you're
only if you're hourly. So, if you are exempt, then no.
So a question too. So one of my employees says, "Well, I don't want to take my lunch." So
you just can't be in control of them, and you have to make that lunch available. So what that means is you shouldn't be assigning work, things like that. You shouldn't be assigning work. You shouldn't be, being on the wink wink, because if you do the wink wink and then you give them work to do or whatever else, then they can come back on you anytime.
Right.
And it goes back years. You know what I mean?
back here.
So again, that's a perfect example of, I talk a lot about legal responsibility and ethical responsibility, what's actually right. As an employee, if I know I like to work through lunch and I know what the rule is related to that, I shouldn't be getting mad at my employer later and bringing a claim because I technically did not take lunch,
Right.
even though the lunch was made available and I didn't want to go to lunch all that time ago.
Oh.
Okay, that's foul. Okay, and so, but that is there. A lot of folks, a lot of employers get sued on technicalities. So employers, you have to be careful about your off-the-book understandings that break the law.
Right.
Even if you're nice, even if you're a good employer, things like that, the best way to do it is to just stay out of that realm, because they can bring that against you anytime. I've seen it happen. People change. And by the way, whereas in a personal injury case, for sure, for instance, my claim dies with me if I got in a car accident and then I died, not related to the car accident. My family can't come and get that. But what my family can come and get is wages. It can get things that I'm contractually obligated for to receive because I have already performed.
Got it.
So
That's
wages would be in that category
That's very
because the
interesting.
work has been done. And so therefore someone can actually come after that, So, we're getting kind of hairy into some other issues here, but there's a matter of some claims continue to exist. So I say that to say, just because that's the same reason General Contract 101 is have a contract, have an email that states your understanding, because you're dealing with person X, but if you pass away and now you're dealing with person X's son,
So
or daughter.
that's interesting, because we also do probate
Right.
here at Pro Se Legal, and that's a question that we have not asked.
Right.
Especially, we just had a young man, matter of fact, he's 55, he had died of COVID and was
Mhm.
still working. So that's
Right.
that's a question that I'm gonna have to ask
Right.
his family,
Right. Right. What is he?
has he received all of his wages?
Has he received all of his wages? Is there anything out there that he's contractually entitled to receive that he has already earned?
Interesting.
So those things are out there. So whereas it varies from state to state, but in California, your personal injury claim dies with you if you die for an unrelated reason. But if I get in a car accident and I die because of the car accident, this is getting into Corey Wex area, but if I die related to the car accident, then the claim is not mine. The claim is for who survived me.
Right.
And so, that's kind of a thing. So I say that to say, a lot of times you guys have gentlemen's agreements and things like that, and it's handshake and nothing's in writing, and you think people get offended if they ask you to put it in writing. No, let's do this because we're friends,
Right.
not despite the fact that we're friends, because I could be dealing with somebody else tomorrow, and so could you. But the performance is still going on, particularly if it's continuous, or the performance may have already occurred.
Right.
The exchange may have already happened, and so someone is entitled to what they're entitled to. So leave nothing to chance, keep it above board. That's always the best thing, because that way you set an expectation and you're in a place where what happens with employers, as a general statement, I'll tell you this for fun and then I'll shut up. If you've got 20 employees, the math works out. You've got 20 employees and you don't give anybody lunch breaks or rest breaks like you're supposed to. So it's an hour penalty for each one, and then you do that for a year. Typically, it's going to be probably $20,000 to $30,000 a person. That's how quickly it adds up. So you just do that 5 times consistently. That's when wage claims build up. You know what I mean? And so when you're doing something that you think is minor, and it might be minor, but you do it consistently, it adds up. And all you need is a hungry plaintiff's attorney that's going to bring something that's a class class action, or he's going to come after, they're going to come after you, whatever the case may be. Now, suddenly you feel morally wrong because, you loaned that employee money. You did right by them.
Right.
You did X or Y. But the law is the law. And so to the extent you must stay above board the best way possible. Ultimately, it protects you.
Good stuff. Very good stuff, and to start to close out here, we at Pro Se Legal can actually assist in wage claims and helping those individuals prepare those documents. And when you need an attorney, then we obviously would be referring you to Attorney Joe Richardson. There's a lot going on. I know there's always a lot of changes, especially in the workplace. And then Linda, oh my gosh, I can't even begin. That's just amazing information. Again, we get a lot of phone calls for evictions, or I have not paid my rent or mortgage and I know I'm going to get evicted. You guys do that. Before we start any paperwork, let's go ahead and refer you to a housing counselor. And for those of you that are thinking, I'm not sick, I'm not old enough, I don't need power of attorneys, everybody needs a power of attorney, especially in this day and age. People are passing away at a younger age, not just due to COVID, but because of strokes, or car accidents, or just other things. Most of us that have children have adult children. They're in college. Let's go ahead and make sure that we have those things. My son was on the pro rodeo circuit riding broncs. God forbid if he'd have been hit, kicked in the head by a bucking horse. Thank God I had a power of attorney for him. So I want to thank everybody for joining us tonight. I really want to extend the hand of fellowship to Attorney Joe Richardson and to Linda Jackson. Thank you so much. This has just been a wealth of information. And so this is Kim Lewis from Pro Se Legal. We will have a contact information for Linda Jackson, Inland Empire Resource Center, for Attorney Joe Richardson from McHugh and Wright, Arvello, and then obviously Pro Se Legal. Thank you all. Have a good night.